Our last case is Avery versus Michigan. Good afternoon. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you keep track of your own time, and you may begin when you're ready.
Good morning, Your Honors. My name is Paul Matuka, and I represent the plaintiff in this matter, Mr. Chamar Avery. Across the country, legislatures have had to confront the difficult and important issue of compensating people who lost years of their lives due to wrongful convictions. These legislatures have developed different approaches, different statutes to accomplish this goal in attempting to address a number of the issues that arise when legislating on this matter. Two of those issues are, A, how to promptly provide those who deserve and need compensation with it without undermining the integrity of the process, and B, how to address difficult issues about evidence that may no longer be available based on decades-old convictions. Michigan's legislature made a conscious decision to address both of these issues by focusing on a single element, new evidence. By doing so, the Michigan legislature intentionally limited the scope of people who were qualified to seek compensation, limiting it just to those whose convictions were invalidated based on new evidence demonstrating innocence. And the legislature also ensured that in almost every case, the relevant evidence for a WICA claim would be available for all parties. This also ensured that it would be a faster process. The trial court erred by failing to resolve this matter on an evidentiary hearing focused on the issue of new evidence, as noted by Judge Jansen in her dissent from the Court of Appeals. And the most critical error, however, by the trial court was admitting and then considering substantively the testimony of Jacqueline Barker, who had also testified at the underlying criminal trial. However, beyond these statutory issues, the trial court erred by ruling against the great weight of the evidence by crediting the inconsistent testimony of Jacqueline Barker against all of the other live testimony and evidence presented. And then, despite the inconsistencies within her testimony, as well as between her testimony and the plea hearing transcript of Terrence Holm, that the court also credited. I'd like to focus first on the issue of what evidence is relevant for purposes of WICA Section 5.1c. And here, as this court has noted in the multiple WICA cases it's seen before, we start with the text. And the text expressly states that new evidence demonstrates that the plaintiff did not perpetrate the crime and was not an accomplice or accessory to the acts that were the basis of the conviction, results in the reversal or vacation of the charges in the judgment of conviction or a gubernatorial pardon, and results in either dismissal of all the charges or a finding of not guilty on all of the charges on retrial. Contrary to some other cases that this court has had to refer to a dictionary, I believe that was the Maples case, Maples v. State, which is another WICA case, the legislature specifically defined new evidence. And it is, as this court interpreted, evidence that was not presented in plea hearings or the actual trial leading to conviction. And plaintiff here asks simply that this court adhere to what the legislature wrote.
So I think the problem is not, in my view, the definition of new evidence. The work that needs to be done is, does that new evidence demonstrate that plaintiff was not the perpetrator of the crime and was not an accessory or accomplice to the crime? That is what the court has to determine of whether or not he's entitled to a remedy under WICA, right? So yes, we have new evidence, but to demonstrate, the judge has to fulfill the obligation to say, does that new evidence actually establish that he didn't commit the crime or do that? So yes, you have to have new evidence to get in, but how does that then somehow tie the hands of the court evaluating this from only looking at what has been presented by the defendant? Because the court has to establish that that standard has been made.
Right, and the clear and convincing standard does apply here, obviously, to
So-
the new evidence requirement. And what I understand your question to be is, essentially, how is the court going to determine, hey, does this new evidence actually demonstrate innocence? And that can be done either by a stipulation to facts as to what the underlying acts were that are alleged in the crime, or you can look at the underlying transcripts if necessary, but not for substantive value. The question that the legislature explicitly wrote is, what does the new evidence demonstrate? Not is it weighed against the old evidence, but is it inconsistent with that old evidence?
So they're supposed to sort of put like a new evidence blinders on and only look at the new evidence.
Precisely.
And that is, and so even if under the new evidence blinders, it might suggest that they didn't actually commit the crime or participate in it. But if you were looking outside the blinders, there is evidence that actually suggests that they did, or that outweighs the new evidence. That individual is still entitled to compensation. You think that's what the legislature intended, that somebody who may have actually committed the crime, and I'm not saying, passing judgment one way or the other in this particular case, but reading the statute, that somebody who was the actual perpetrator of the crimes and or an accessory or accomplice is nonetheless entitled to recovery as long as just looking at this new piece of evidence.
Yes, Your Honor, and honestly, the reason for that is because the state's already had at least 2 bites at the apple to secure a valid conviction. And every single person who brings one of these claims was incarcerated for a term of years under a conviction that's no longer valid. And the state was unable to secure that. So this person lost years of their lives.
Understood, but you agree with me that there are other circumstances in which somebody may not, why they haven't been charged again, or what have you, why they're even entitled to sort of make this claim under WICA, apart from the new evidence that they might be offering?
Honestly, it's because that's what the legislature wrote and intended. The legislature, as Justices Zara, Clement, and Viviano noted in their dissent in Ricks, the legislature can essentially make any limitations and rules on how it decides to waive sovereign immunity. And in this case, the legislature designed a system that was intended to provide for relatively quick compensation for a very, very small subset of people who have been released. As this court has recognized, it doesn't apply if it's just a mere ineffective assistance of counsel claim or something else along those lines. The reversal or vacation has to be on the basis of new evidence rather than something else. So we've already significantly narrowed the scope. And then the issue is, if we expand the definition of new evidence and start bringing in issues of old evidence, we're looking at third, maybe fourth full trial. And that begins to open up a Pandora's box as to, okay, how is this court the trial court, supposed to determine make credibility determinations based on a cold record? If a witness is not available to testify, who testified in the underlying criminal conviction, that evidence may not be available beyond a transcript. And yes, you may be able to get that in under the exception to the rules of hearsay as an unavailable witness, but you still then start making these credibility determinations from the new evidence versus this old evidence. And as I explained in my supplemental brief, that is one of the things that I think that the legislature was focused on, as several other legislatures around the country have taken different approaches to how they're going to address the problem of old or unavailable evidence that someone might have. Michigan did not do that. They chose to focus on what evidence would be available to all parties. And that's exactly what they did here.
So what's the difference between having a full evidentiary hearing and having a trial? I mean, at an evidentiary hearing, you can still bring in witnesses and solicit evidence. As a practical matter, what's the difference?
Your Honor, I think at the end of the day, there's probably less of a difference. From my perspective, in an evidentiary hearing, I'm thinking a day, maybe two. You're not going to have consecutive, like a week or more of trial. And when we start talking about, more complex cases that may have had, not just a single witness in the criminal case, but multiple witnesses on both sides, you're going to start running into issues where this court of claims trial may span into 2 weeks or more, on top of the issue of, how are we going to, once again, weigh the credibility of this cold record versus the present testimony?
I hear you as arguing that your client is entitled to less process, which strikes me as a strange argument to be making. Is that what you're saying? Your client deserves less process, just an evidentiary hearing instead of a full trial?
Your Honor, if the evidentiary hearing is not sufficient to resolve the matter, obviously it can go to a full trial. There's nothing in the WICA or the Court of Claims Act that prohibits it. We just feel that given the structure of the statute and all the limitations that we've identified in our application for leave to appeal, that the legislature intended for this to be a truncated process. And this court recognized that in Ricks, where it said, the first thing you do is determine eligibility, and then the second thing is you just calculate damages or compensation. And so at the end of the day, if a case needs to go to trial, it can, but I think that is the last thing that is envisaged by this statute, because you also have to remember, these people who are released, it's important to get them compensation as soon as possible to help them start rebuilding their lives. And I think that's also something that the legislature was considering. And very briefly, because I want to reserve a few minutes for rebuttal, I just want to touch on the issue of ruling against the great weight of the evidence. Having read that plea hearing transcript, there's no detail in it that, as the trial court said. It had to be stopped because Terrence Holm wasn't saying what the court in that wanted him to say. And so for the trial court to say, oh yeah, this is credible, he absolutely knew what he was talking about. Terrence Holmes had already decided to plead guilty. And then he didn't say what the court wanted, so the court sent him out and had him talk to his mother. And then he changed his story to be consistent with the prosecution's narrative. And we've also identified the issues with Jacqueline Barker's testimony, so I just wanted to briefly touch on those. Thank you.
Good morning. May it please the court. Gallant Fish on behalf of Appellee of the State of Michigan. With me at counsel's table is Solicitor General Ann Sherman. Your Honors, the issue in this case is ultimately whether the WICA requires a showing of actual innocence. Now, the statute does require a number of showings that are largely procedural in nature. Did new evidence result in the reversal of the convictions? Did new evidence result in the dismissal? Was the plaintiff serving a concurrent or consecutive sentence? And this court, over the past few years, has heard and decided several cases that address those procedural aspects of the statute. But this case concerns the WICA's substantive element. Can the plaintiff show, by clear and convincing evidence, that new evidence demonstrates that they did not perpetrate the crime? This was the first case that went to trial on that issue. Now it's the first case to raise it before this court. Plaintiff argues that this provision ultimately requires something less than a showing of actual innocence. Relying on a misreading of the statute, he argues that the court was required to look only at the new evidence and, without weighing its credibility, ask, is that evidence incompatible with guilt? So under his reading, the court should have awarded his client compensation despite finding that plaintiff most likely did commit the crime at issue. And that reading would be a dramatic departure not only from the text of the statute, but from its stated purpose, which is to compensate the actually innocent. So instead, under a plain language reading of 1755(1)(c), the court below asked the right question. And that was whether plaintiff had established innocence by clear and convincing evidence. And the court properly found that plaintiff had not made that showing. This court asked 3 issues in its MOA order. On the first issue, the parties no longer disagree, and both parties are in agreement that the statute authorized the Court of Claims to conduct a trial. So plaintiff argues under his reading of the statute it wasn't necessary, but both parties agree that it's at least permitted under the statute. So turning to the second issue, which is really the crux of the appeal, and that is whether the Court of Claims was limited to considering only new evidence in making its determination. Our position on that issue is straightforward. 1755 1C sets forth the elements that the plaintiff must prove. It does not limit the evidence that the court may consider. And so plaintiff's reading has a certain surface level appeal, where if the statute is asking about new evidence, why would anything else be relevant? Why would we need to look beyond that new evidence? But if we think beyond surface level, that reading quickly falls apart. First of all, the statute doesn't actually say anything about what evidence the court may or may not consider. It says nothing about relevance or admissibility, and by its terms, does nothing to limit the court to certain evidence. Also, in no other context, we read the elements of a claim in this way. If we think about a libel and slander civil claim, where there's a statement at issue that must be false, no judge is going to instruct the jury, you must look only at that statement to determine whether it's false. That would be both contrary to the rules of evidence, which allow consideration of relevant and admissible testimony, but it also would make the inquiry impossible, because a statement alone is not enough to let you know whether that statement is false. So the same is true here, where yes, the new evidence is at issue, but the rules of evidence allow for consideration of any relevant and admissible evidence in making that determination, and practically the court can't determine, looking only at the new evidence, whether that evidence demonstrates innocence. If we think about it on even a basic level, if we look at the alibi testimony in this case, alibi testimony that the witness claims to have been with plaintiff at a certain time in a certain place, that alone doesn't tell the court anything, because the court doesn't have the evidence of guilt before it to know, does this demonstrate innocence compared to the evidence of guilt? So plaintiff concedes this and says, okay, well, the court can look at the evidence of guilt, but only facially. It can only compare the evidence of innocence, the new evidence, to evidence of guilt, and make this facial comparison. So essentially asking for some type of C10 standard of review, where looking at the face of the evidence and without weighing its credibility, has he made his required showing? But that's problematic for a few reasons, most notably that nothing in the text limits the court to only a facial review of the evidence. Nothing indicates that the court, as a fact finder, is not permitted to weigh the evidence. That would also render the clear and convincing standard meaningless, because the court can't find clear and convincing evidence of something that's not permitted to evaluate the evidence, weigh its credibility. Plaintiff argues in his brief that the clear and convincing evidence standard doesn't actually apply to the showing of innocence. It just applies to more this baseline showing that there's some new evidence that tends to show innocence. But the ultimate fact to be proven is that the plaintiff did not perpetrate the crime. New evidence is the means to get there, but that he did not perpetrate the crime still has to be shown by clear and convincing evidence. And so a plain language reading of the statute permits the court to consider all relevant and admissible evidence, to weigh that evidence, and determining whether the plaintiff has made his required showing. Finally, on the third issue, whether the Court of Claims clearly erred, the court did not clearly err. Plaintiff argues that for his theory of the facts, but alternative theory of the facts does not give rise to a definite, firm conviction that a mistake has been made. The court set forth detailed findings of facts, and those findings were supported by the record. And so, Your Honors, while this case is unique, and that's the first of its kind, legal and factual issues are straightforward. The Court of Claims asked the right question and reached the right conclusion. So unless the court has any questions, I'll yield the rest of my time.
Do any other states follow the procedure that the plaintiff is urging and only allow a court to look at, sort of in a vacuum, the new evidence presented, but not compare it to any of the other evidence, which presumably is all the other most relevant evidence in the case? Just sort of stick your head in the sand as to all that other evidence? Is this what other states are doing?
I'm not aware of any states that do that, Your Honor, and plaintiff makes that point in his brief that no other state limits the court to only new evidence, and argues that that is in support of his argument, because he argues that Michigan statute does do that, but I'd argue that's not supported by the text of the statute. Thank you.
Counsel, do the rules of evidence apply to this proceeding?
Yes, Your Honor.
And so, if you believe that the legislature wanted to depart from those rules, don't you think they would have done so explicitly in this statute?
Your
In
Honor,
other words, if they wanted to exclude lots of other evidence that almost everyone would say would be relevant to make this determination, don't you think they would explicitly say, we don't want you to think about all these, admit all this evidence that otherwise, in every case, in every context, civil, criminal, probate, family, would be admissible, but here, we don't want you to think about that?
Your Honor, I don't think the legislature affected the rules of evidence. What I think the legislature did is by setting the standard, which is new evidence demonstrates, not old evidence, it implicitly defines what is relevant. Because if the only question is what does new evidence demonstrate, then nothing else is relevant. Because what the plaintiff must show is that the new evidence is inconsistent with guilt. And I want to address something real quick in terms of what other states do. And I can't remember off the top of my head, but at least one other state, the way you get compensation is exclusively through a gubernatorial pardon saying you weren't guilty. No fact-finding required, just a gubernatorial pardon. Many other states require a showing of actual innocence, and that's where things get tricky, and they start including things along the lines of permitting evidence that may have been obtained in violation of the Fourth Amendment, admonishing the court to take account for the difficulties in assessing evidence that may no longer be available, may be lost. And so here, the legislature made a very conscious decision. What we are weighing is the new evidence and nothing else. The issue of, whether or not the person is innocent, I think, once again, we need to refer to the fact that these people were incarcerated. There is no valid incarceration for them. There is
Can
no.
I ask, just to clarify, under your theory of new evidence only, a WICA plaintiff would also not be able to introduce evidence that was exculpatory to him from the previous trial, right? So other evidence that actually supported actual innocence would also be precluded.
Yes, Your Honor.
Okay.
Thank you.
Thank you both. The case will be submitted and the court is adjourned.